But I was just the lookout. Not a great excuse in Iowa, thanks to the aiding and abetting statute. I'm Laura Snyder, the Iowa Law Geek, and we're geeking out about aiding and abetting today. So let's get into it. Iowa Code Section 703.1 is the aiding and abetting statute, and it is a form of prosecution. It is not a crime in and of itself. So it's a theory of prosecution, and it allows a prosecutor to charge someone who aids and abets in the commission of the crime in the same way as they can charge the principal, the person committing that crime. So this is what makes that person who acts as the lookout while an assault occurs also guilty of an assault, or the person who acts as a getaway driver in a robbery also guilty of robbery. And why does this exist? I don't know for sure, but what I would theorize is that but for or without the person who aids in the commission of the offense, i.e. the getaway driver, the crime may or probably wouldn't have ever even occurred. And some of you may be thinking, well, that's not fair. They're not actually the person who threw the punch that broke the person's nose, or the person who ran into the bank and took the money out of the teller, which arguably that person is worse. They committed the violent portion of the crime. But in some offenses, as long as they aren't mandatory sentences, for certain crimes, a judge could give the aider and abetter a probation sentence while giving the principal a prison sentence. Or it allows a prosecutor prosecutorial discretion in which they could amend the crime down in exchange for that aider and abetter to testify against the principal. And I'm not going to go into prosecutorial discretion today, but we will do a video on that at some point. So what do you think, my fellow law geeks? Do you think aiding and abetting is appropriately a theory of prosecution, or do you think it should be its own statute like conspiracy?